major breaking news out of the state of New York. The United States District Court for the Southern District of New York has denied a motion to dismiss by the state of New York to dodge the metaphorical bullet of a Second Amendment challenge to the state's quote-unquote assault weapon ban. This is a huge victory for the Second Amendment. The attempt to use these procedural hurdles to thwart the Second Amendment challenge has utterly failed. We're going to talk about next steps and what this means for your rights in New York in just one moment. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist, that's right, a top 5 finalist in 2 separate categories for the 2024 Gundy Awards in Las Vegas. The first category is Top Male Influencer in the Second Amendment space, and the second is Top Voices of the Second Amendment. I am honored to be a finalist in both of those categories. We'll do a separate video about that shortly. But in the meantime, huge, great news out of the state of New York. Judge Kenneth Karras, a George W. Bush appointee, has denied a motion to dismiss by the state of New York effectively in the case of Lane versus Rocha. Now, in this case, there is a challenge to the state's quote-unquote assault weapon ban, which, as you know, assault weapon is a propaganda term brought to us by anti-gunners. But what they're really talking about here is standard and ordinary semi-automatic rifles that virtually all Americans all across the country have in one form or another, at least if you're not in a blue state that hates guns. In your closet or somewhere else, an AR-15 style firearm. And New York, of course, has essentially banned these, and the plaintiffs have brought a lawsuit saying that they want to buy these and acquire these and possess these for various lawful purposes, including but not limited to self-defense. But today I'm happy to report, despite the best efforts of the state of New York to try to get this case dismissed on procedural grounds, specifically arguing that there was alleged lack of standing by the plaintiffs, a very borderline argument. Ultimately, that argument has failed. This is great news. Judge Kenneth Karras, again a George W. Bush appointee to the federal bench, has allowed the Second Amendment challenge to the state's quote-unquote assault weapon ban to move forward on the grounds that indeed the plaintiffs have standing to challenge, because they made it very clear that they're law-abiding citizens, they want to own these guns, and they're denied the ability to buy these guns or even to apply for a license to get these guns, if you will, because the state has essentially banned them. So the state argued in various ways that the plaintiffs lack standing, which is not an unusual situation we see by defendants to try to argue that there is lack of standing. The reason why the lack of standing is an important argument for defendants is, as you may recall, under the United States Constitution, Article 3 creates the federal judiciary. Article 1 is the Congress. Article 2 is the President. Article 3 is the federal judiciary. Under Article 3 of the U.S. Constitution, the federal judiciary is given jurisdiction to hear what are known as cases or controversies. What this means is these have to be actual live disputes that not only a plaintiff is suffering some sort of injury. In this case, the alleged injury is the plaintiffs want to be able to exercise their Second Amendment rights, to be able to acquire AR-15 style firearms, and the state is denying them that right, which is that ability, which means it violates their Second Amendment rights. That is a constitutional injury. In fact, that is what the plaintiffs argued, and the court accepted. And then, of course, if the court were to enjoin this law, then obviously that would redress, meaning it would fix the problem for the plaintiffs. And because Judge Karras said that indeed the law is infringing, allegedly, apparently, on the Second Amendment rights of these plaintiffs, because they want to acquire these types of semi-automatic rifles and they're not allowed to do so because of the law, they don't want to go to prison. And again, because a court order that would enjoin these laws would redress or fix this problem, there was indeed standing. Now, what's quite interesting here is the government made these arguments that the plaintiffs lack standing. They argued a couple of different things. They tried to say that the plaintiffs had to go get a license first before they could bring this lawsuit, and without getting that license, they lack standing. But the government, I should say the court, Judge Karras here, said, nope, that's obviously absurd, because why would they get a license to buy a gun that they clearly cannot buy? So it's a waste of time. It's futile for them to go get any kind of a license or take any further steps, because it's clear that the type of gun they want, which is a semi-automatic firearm with various things like telescoping or folding stocks, a protruding pistol grip, and so on, they can't buy it. So there's no reason to waste everyone's time to have them go through a futile process to exhaust administrative remedies or anything along those lines. So Judge Karras rejected that argument by the defendants. We should also applaud, I should say, by the way, the excellent lawyer in here, and I'll tell you why in a second, of Adam Crowd of the Second Amendment Foundation, and also of Cody Wisniewski of course, the Firearms Policy Coalition Action Foundation. Two excellent lawyers there, Adam and Cody. I should specifically say I thought one of the most creative things they did is they submitted, in support of their argument that the plaintiffs have standing, a series of press releases and boasting by district attorneys, the state of New York, and so on, about how they were actually enforcing this semi-automatic rifle ban, how they were actually charging people, indicting people, and so on. And that allowed the plaintiffs to say, look, we don't want to be in a press release charged with a crime, so we're going to sue now pre-enforcement so we don't have to go to jail before we can assert our rights in court. We want to sue now. I thought that was a very smart move by the lawyers. I should note that the third lawyer involved is Nicholas Rotzko of the law firm Phillips Lytle there in Buffalo, a prominent firm in Buffalo, was also on the brief in support of their clients, Mark Lane and James Sears. So anyway, excellent lawyering, because they brought to the bear and showed the court that, hey, people are going to jail and being indicted and charged over this violation of an assault weapon if they possess these things. And the court's like, yeah, obviously this is a real danger, a real risk of prosecution, and therefore the plaintiffs have standing to bring this lawsuit. And he denied the motion to dismiss. And then what's quite interesting, and this is very good news, this is in some ways as good a news as the motion being denied, is the court then scheduled summary judgment. This is very smart. It's going to move this case along with speed. Specifically, Judge Karras said that the plaintiff's motion for summary judgment, which has been held in abeyance pending the outcome of this motion to dismiss, is due no later than February 9th, 2024, and the defendant shall file responses by March 11th, and then the plaintiff shall file reply by March 25th, which means that the federal district court judge Karras in New York will have these briefs, apparently, unless there's an extension of time, by the end of March to go forth and make a decision on the merits. Now, the reason why it's so important that they're going to address this on the merits, and I think that the court's already given some indication of how he might rule. He said he's not, but if you look at some of the language he's citing here, if you look at page 17 of the opinion, which I'll put a link to down below, this is what the judge writes. He says the plaintiff's desire to possess assault weapons, and by the way, he specifically put in a footnote that the reason why he wanted to use the phrase assault weapons in this opinion is because that is what these specific guns were labeled by the state of New York in the statute. So Judge Karras specifically says, because this is how New York labeled these guns in the statute to make it crystal clear what his opinion says, he said he will use the phrase assault weapon because, again, that is what's used in the statute. Not because he agrees with the term or thinks it's accurate, but specifically for clarification, so there's no confusion. So when I read the words assault weapon in this context, and when Judge Karras uses it, please keep that in mind. So this is again what Judge Karras writes. Again, plaintiff's desire to possess assault weapons involves a course of conduct affected with a constitutional interest. The Supreme Court has held that the Second Amendment protects the sorts of weapons that are in common use for lawful purposes like self-defense. Citing to Heller, very good language. In common use for lawful purposes like, not exclusive, like self-defense. Citing to Heller. Goes on to say, plaintiffs allege an intent to exercise that right by purchasing different models of AR-15 style rifles, which they allege are a particularly popular type of firearm among gun owners, citing to the complaint. But what's interesting, and this is critically important, that the judge then cites to a case from the Second Circuit Court of Appeals. See also Cuomo 804 F3rd at 255, citing, and this is what the Second Circuit case said, quote, recognizing that, quote, Americans own millions of the firearms that the challenged legislation prohibits. Then the judge goes on, and this is really telling, I think, as to where this case is going to go. I feel very good about where this case is, given what this judge just said here. No party disputes that, even accepting the most conservative estimates, those weapons are in common use as the term was used in Heller and Bruin, citing to the Cuomo case. hoisting the left on their own petard. Because in the Cuomo case out of the U.S. Court of Appeals for the Second Circuit many years ago, they conceded and they admitted, as they must, that there are millions of AR-15 style firearms all across America. But the left didn't care back then because they were playing games and ignoring Heller and just interest balancing away our rights. So they made all these concessions. They made all these admissions. The court made these findings, which we're now going to be able to use against them to vindicate our rights that never should have been violated under the Second Amendment and under, of course, the Heller decision from 2008. So again, Judge Karras again states, no party disputes that even accepting the most conservative estimates, these weapons are in common use as the term was used in Heller and Bruin. Nor does either defendant challenge, at least at this stage, plaintiff's allegations that AR-style weapons are typically used for self-defense and hunting. Thus, their desire to possess such weapons, meaning the plaintiffs, their desire to possess such weapons is thus clearly affected with a Second Amendment interest. So this is great news out of New York. You have a federal district court in the Southern District of New York, which is in White Plains and Manhattan, some arguably the most liberal part of the state, having a very favorable ruling so far dealing with this quote-unquote assault weapon ban out of New York State. We'll see what happens in this Lane versus Rokaw case going forward. We certainly will keep you apprised. It looks like there's going to be some major briefing going on over the next 60 days. And again, as that occurs, we will keep you informed, and then we'll see what the judge does. Presumably, if all the briefs are in March 15th, I would say he probably would be able to get a decision out in a case like this, which I think is relatively straightforward, probably in about 90 to 120 days is my guess. I don't know how busy or big that docket is that Judge Karras has, but I'm guessing 3 to 4 months he'll be able to get a decision out in the normal course is my best guess in the Southern District of New York there. All right. Hope you learned something here today at the Four Boxes Diner. If you haven't subscribed, please do so. Make sure you subscribe, even if you think you've done it before, because some people have complained they've been getting kicked off. Don't know how that happens, but they've been saying it. So make sure you subscribe. Don't forget to follow me on X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.